Thank you, Lord. My ladies, I can confirm, not deny, but confirm that I rest my case on aggregation solely on subclause E. I'm not at all tempted by the prospect of trying to rescue subclause B by some sort of emergency first aid, so I put my case solely by reference to subclause E.
Thank you.
My Lord, I move then to the question of condemnation. May I bridge the gap, as it were, between my aggregation submissions and my condemnation submissions by, I hope with appropriate delicacy, drawing attention to one issue in relation to the judgment that is currently under appeal, which is this, that the court knows that the judgment took 7 months to emerge as compared with the period of 3 months which is laid down for judgments in the business and property courts. Now, I'm sure I speak for all counsel and indeed all those sitting behind counsel. None of us would want to understate or underestimate the pressure that can arise in a matter of judicial business, particularly when there's a long sequence of difficult judgments that have to be prepared. So nothing I say derogates from that. But I do simply draw attention to the fact and identify the applicable statement of principle in relation to judicial delay, which is, I needn't turn it up, I'll just read it out. It's at tab 20 in the second authorities bundle in a case called Floriat Investment and Churchill, as it happens, another appeal, a different appeal against a decision of the same judge. And the principle that was laid down in that case, where again the delay was, or the time taken to produce the judgment was 7 months rather than the appropriate 3 months. The principle laid down in paragraph 87 of that case was as follows: whereas in this case there is delay beyond this time, i.e. the 3-month period, it will be appropriate to scrutinise the judgment with particular care, and an appellate court may be more ready to conclude the judge has gone wrong. However, as counsel in the case recognised, delay is not itself a reason for allowing an appeal. That last proposition is obviously correct, and that is why we do not rely on delay as a ground of appeal. If this court concludes that this judgment is properly sustainable and is coherent and should be sustained, notwithstanding the criticisms that I seek to make of it, then so be it. The fact that there has been delay will be nothing to the point. However, I will just add this further observation in relation to this matter. One difficulty that can arise where one comes to look at a case some number of months after hearing the relevant evidence and considering the documents and hearing the submissions is that it can become very difficult properly to set accurately in context the actions and inaction and thoughts of a particular party or witness, because one loses a firm grip on all the contextual evidence. And I shall immediately give the court an example of the way in which this type of problem might be said to manifest itself in this case. I am going to, in due course, I'm going to be critical of essentially exculpatory findings that the learned judge made about Mr. Prentice's state of mind in 2007, particularly in 2017 and 2018, when Mr. Prentice was dealing with the later stages of the Reno transaction, which took up a lot of time in evidence below. And as I will attempt to demonstrate, certain apparently, on one view, surprisingly benign findings are made about Mr. Prentice's state of mind, in connection with our case that he must have strongly suspected in a focused way that Mr. Jones was misusing client money. And I will be seeking to persuade this court that those findings are unsustainable when one fully takes into account what was going on in the background at Jirehouse. And in particular, one fully takes into account the very stark evidence to the effect that Jirehouse as an organisation and Mr. Jones as an individual was under intense and persistent financial pressure to the extent of not being able to pay, to put it mildly, debts as they fell due. I may or may not be able to persuade this court that an error of that nature has occurred, but when I am seeking to develop that submission, I recognise, and I respectfully invite the court to recognise, that problems can arise when anyone, a barrister or a judge, comes to look at a case containing quite detailed evidence and quite a lot of documents 4, 5, 6 months after the matter has been considered, been before the court and has been the subject of submissions. It remains to be seen whether I get anywhere with those criticisms, but that is the context in which I make them.
Could I just understand the extent of this? You plainly made a number of criticisms of the judge in your grounds of appeal, including failure to consider important pieces of evidence, inadequate regard to contemporaneous evidence. But you don't specifically, it isn't specifically referred to in your grounds that that delay doesn't feature in your grounds, shall I put it that way?
No, it does not, and delay in itself, delay is not a ground of appeal. I have to establish, having regard to the principle of appellate restraint that we have already discussed and all that flows from that, I have to establish that there are substantial deficiencies in terms of reasoning or logic or evidential analysis or maybe errors of law, errors of construction, substantial deficiencies in this judgment. And I was going to make this point also by way of a preface to my condemnation submissions. I'm under no illusions about the nature of the condemnation appeal. I do not attempt to persuade this court that the condemnation appeal should be allowed because of a small number of very fact-specific, maybe text-specific criticisms of the judgment. I accept that. If that's all I can do in the course of this afternoon, that's not going to be enough for all the reasons that the court...
No, it's a root and branch attack.
It's a root and branch attack.
Conclusion, yeah.
The learned judge, for the reasons matter not, the learned judge, with great respect, fell into error, I will be submitting, in a fundamental way, or in various fundamental ways. And the consequence was that despite very properly and carefully, in these respects, making some very damaging findings against Mr. Prentice, despite doing that, in the end, he treated Mr. Prentice in an excessively benign way when he came to form conclusions as to what Mr. Prentice knew, whether by way of actual knowledge or by way of blind eye knowledge, and in relation to that, when he formed conclusions as to what Mr. Prentice must have suspected in a focused way about what Mr. Jones was up to during the relevant period. So, my Lord summarises it exactly when by using the term a root and branch attack, that's exactly what I am attempting to present to this court, and that's what I need to do, I accept, if I am to make headway with the condemnation appeal.
The judge had transcripts.
Yes, he did.
Of the evidence.
He certainly did, and he was therefore able to go back to the transcripts and see what had been said by the witnesses, and there are certainly passages in the judgment where he quotes accurately from relevant things said by witnesses. I certainly accept that.
And are you going to be taking this to transcripts?
On occasion, not in great detail, but there are certain points I'm going to extract from the transcripts.
Thank you.
I already have mentioned appellate restraint, and I'm very alive to the court's familiarity with the relevant principles. In the passage from Lord Justice Legate's judgment in Abeliadsoff, I'll simply read it out. His Lordship cited a passage from an earlier case, Henderson, in which Lord Reed explained what the sort of thing that an appellate has to show when making the sort of attack that I'm making in this case. You have to show that the judge's conclusion that his under attack was plainly wrong. We all know that doesn't mean that merely that the Court of Appeal considers with a high degree of conviction that it would have decided the case differently. We know that that is not what that phrase means. No, instead one has to identify, this is quoting from Lord Reed, a material error in the judge's process of reasoning, such as a material error of law, or the making of a critical finding of fact which has no basis in the evidence, or a demonstrable misunderstanding of relevant evidence, or a demonstrable failure to consider relevant evidence. Or one has to show, or the appellate court must be satisfied, again I quote, that the judge's conclusion cannot reasonably be explained or justified. And that's the task I set myself as I begin my criticisms of the judge's approach to condemnation. In a brief exchange this morning, I indicated the differences that may arise between me and my learned friend as to the correct approach to the concept of condemnation in this field, and I won't say what I said then, and I won't go back into those areas at this point. In a sense, it is for my learned friend, if necessary, to make good his attack on the judge's reasoning on the first issue, because the judge agreed with me in the judgment at paragraph 24 that it can be, to prove condemnation, it can be sufficient to establish that the condoner has in some sense known of and condoned a pattern of dishonest behaviour of which the particular fraudulent act forms part. So I agree with the judge about that. His finding reflects a conclusion that was reached on slightly different wording in the Karim case, and I shall leave it to my own friend, if he chooses to do so, to seek to persuade this court that approach is wrong. Where I do need to, in opening the appeal, I do need to develop a submission as to the judge falling into error in this area, is in relation to what I call the judge's fallback position, which is set out in paragraph 143 of the judgment. Perhaps it might be helpful to turn that up. Yeah. Tab 7.
This is 144.
144, yes, 143 through to 144, indeed. This is his, as it were, his secondary evaluation. Last sentence of paragraph 143, even if, contrary to my finding, which I need to displace, he had suspected that, namely misuse of client monies, the suspicion would have been a suspicion about the use of client monies to address temporary exigencies and pressures, and not a fraud of the nature and scale of that involved in the surplus funds claim or the Dragonfly loan claim. And as my lord says in 144, towards the end of that paragraph, at the end, the judge goes on, it may be that had Mr. Prentice looked into the question of whether client monies were being used to address temporary exigencies and pressures, that would, by one means or another, in the event, have prevented Mr. Jones from perpetuating the fraud in the Tamworth Castle transaction. But that causal link is not that provided by the terms of clause 2.8. Well, just as it were in passing, in relation to that passage in paragraph 144, it would not be right to say that in order to prove condemnation in the relevant sense, an insurer has to prove not only that condemnation occurred, but also that the condemnation was of causal effect, in that it caused the fraud to occur, or in some causative sense allowed the fraud to occur.
That's not what the clause says.
No, I'm sorry, my lady.
That's not what the clause says.
No, exactly, indeed.
I thought you were going to make a slightly different point, which is that it's unnecessary for the insurer to show that there is knowledge or suspicion of a specific level of dishonest behaviour. It's enough that what is known or condoned or suspected, or however you put it, was behaviour of the type that gave rise to the claim, or that type of dishonesty, as opposed to the extent of the dishonesty, which is the judge's fallback. And speaking for myself, I can't actually see any basis for that fallback position, which is that you have to have specific knowledge that what he's doing is helping himself to £1 million as opposed to 500, or that he's doing it short term rather than long term, or something of that kind. What you've got to condone is the taking of the money from the client account and using it for whatever purpose.
Indeed, my lady. I'm most grateful that I can take this quite shortly, therefore, because I was indeed travelling towards exactly that submission. And of course, that submission, that analysis of the position is strongly supported by everything that one knows, which underlines the sacrosanct nature of client money sitting in a solicitor's client account. The court knows, we have the accounts rules, if we need to look at them in the authorities bundle. The court will know that they are highly prescriptive in various ways, and they emphasise, as does the Guide to Professional Conduct, the fundamental importance of keeping client money safe. And of course, all of that flows from the point that I made before the short adjournment, to the effect that solicitors, as a necessary part of their professional life, they have control over and access to very large amounts of other people's money. So one needs these rules, one needs these principles, and there is a bright line between a situation in which a conscientious solicitor is complying with the rules and treating client money very carefully as what it is, namely someone else's money, which is held on trust for the client. And on the other hand, a situation in which a solicitor from time to time, for whatever reason, is using/misusing the client money for his own purposes. There's a fundamental difference between those two situations. And if I can persuade the court that the learned judge was excessively benign to Mr. Prentice and should have made different findings in relation to Mr. Prentice's blind eye knowledge of Mr. Jones's misuse of client funds, then that, I respectfully submit, should have been and should be enough to warrant a finding of relevant condemnation.
You say the second sentence of paragraph 144, that finding, had the judge made it, would have been enough for your purposes.
Yes.
And I presume you also say that what the judge has done there is slightly play down the seriousness of what such a finding would have been. Because what the judge doesn't say is that the use of client monies to address the firm's temporary exigencies and pressures, and that would be a fraudulent misuse of client money.
Indeed.
And in a sense, what he did in fact do, what Mr. Jones did in fact do, might be regarded on a large scale as using clients' monies to address the temporary exigencies and pressures of the firm.
Yes, they were.
In the sense that he was, it seems, intending to pay the monies back eventually from some other source.
He had always succeeded in doing that in the past.
Yes.
But then time ran out. But indeed, the
judge seems to be assuming that in order to establish condemnation or relevant condemnation, it has to be shown that the specific acts which gave rise to the claim on the insurance, the details of those acts have to be the thing which is condoned and not generally dishonest behaviour by the solicitor.
Yes, the judge...
Which is setting the bar too high.
I do indeed make that submission. I do. And in the end, the condone is a slightly exotic but ordinary English word, and in the end it's a factual question. Has the relevant dishonest conduct been condoned or not? And it's not difficult to conceive of everyday situations in which one would readily say that A has condoned B being something wrong, without A having any direct knowledge at all about the fact that B has taken place. The dictionary definition cited by my learned friend uses the colourful example: the college does not condone the taking of illicit drugs. College might condone the taking of illicit drugs. It could be put one way or the other. But if you were to say the college warden or whoever does condone the taking of illicit drugs because the head porter has had a word with the warden and said, I've noticed noxious fumes coming out of that window.
And he does nothing to stop it.
And he does nothing to stop it. The fact that there's a party the next week at which illicit drugs are consumed, which the warden knows nothing about, certainly does not compel the conclusion that specific party has not been condoned. The drug taking of that specific party has not been condoned. It plainly has. Once a pattern of drug taking is established, and the authorities have not done that which they would be expected to do, namely to take steps to put a stop to it, then it has been condoned as a matter of English language, even though there is no direct knowledge of a particular incident. So I make that submission as in relation to the general sense of the term condone. So that is the point that your Ladyship has formulated very precisely. That point, as I understand it, divides Mr. Flenley and myself, and the court understands the submission that I make about it. The test for blind eye knowledge is, I understand, common ground. We have both cited Group 7 and Nazir at authorities 16 at the start of the second bundle of authorities. It may be helpful just to open that up and identify the relevant passage. It's tab 16, as I said, and it's the relevant passage begins at page 158 in the Court of Appeal judgment, paragraph 59. This case concerned allegation of dishonest assistance and was obviously therefore directed towards the concept of dishonesty, which is not the same as the concept of condonation that is being considered in this appeal. But nevertheless, what is said here about blind eye knowledge is accepted to be applicable. Accordingly, one sees on page 158, just below G, one sees this. It is important, however, to understand the limits of the doctrine. It is not enough that the defendant merely suspects something to be the case or that he negligently refrains from making further inquiries. Then reading on, two conditions must be satisfied. The first is the existence of a suspicion that certain facts may exist, and the second is a conscious decision to refrain from taking any step to confirm their existence. And then over the page, reading on in the speech of Lord Scott in star C, I think, Lord Scott said, and this is approved in this, or endorsed in this decision, in my opinion, in order for there to be blind eye knowledge, the suspicion must be firmly grounded and targeted on specific facts. The deliberate decision must be a decision to avoid obtaining confirmation of facts in whose existence the individual has good reason to believe. The court will read on and see what is said there.
Just to understand the context of this, or how it works through into condemnation. And the test is not knowledge here. The test is condemnation. So how does blind eye knowledge fit into condemnation?
My learned friend would say that one must know something. One has to know something in order to be a condoner. He would say, and I wouldn't in substance dissent from this, that if you have no, in very broad terms, no guilty knowledge at all, then you would not be a condoner. You might be very negligent. You might have formed some hazy suspicion and negligently failed to pursue the matter. But that would not be enough to justify the conclusion that you actually condoned significant wrongdoing. Something more is required. So the case was approached below and is being approached here on the basis that focused suspicion on the part of Mr. Prentice that Mr. Jones was misusing client money had to be shown. And I don't seek to understate that or to move away from that. I'm quite content that
But that's enough, is it? Focused suspicion is enough.
you need focused suspicion, and then of course the second limb of blind eye knowledge is evidence showing a decision, a deliberate decision, not to make the inquiries which one might be expected to make or which one ought to make, having formed the focused suspicion in question. But I do have a submission in relation to that, which my own friend may not agree with and may wish to respond to. Everything in this area is obviously context dependent. Here, the court is looking at a solicitor, someone who qualified as a solicitor in 2013, having previously qualified as a barrister. In some cases, a solicitor's conduct and inaction might be defended on the basis that, to put it in a blunt and rude way, the solicitor was a complete idiot who just hadn't grasped the nature of the relevant professional standards and was too stupid to understand what was going on or to work out what should be done. But for reasons that I will develop shortly in a moment, no such proposition could possibly be advanced in this case. There is ample material to support the judge's express finding that Mr. Prentice was both educated and intelligent. And he was plainly both those things. So he was no idiot. He expressly accepted, without qualification in cross-examination, that he was familiar with the relevant principles in the Solicitor's Accounts Rules, and he was familiar with the relevant principles in the Guide to Professional Conduct, as one would expect. For good measure, he also accepted in cross-examination that he was financially numerate and well able to understand and assimilate financial information that one got from a piece of software or spreadsheet on the computer screen, whatever it may be. He had a degree in finance. He worked as a for and then briefly as a regulator, financial regulator in I think Nevis. Accordingly, it's my submission that if the correct conclusion is that Mr. Prentice must have formed a focused suspicion that Mr. Jones was misusing client money.
He had a duty to whistleblow.
He had a duty to, certainly to, at the very least, investigate, ask awkward questions, and he would then have had a duty to blow the whistle. And he must have known that.
Because he's familiar with the professional guide.
Exactly, Molly.
Yeah.
So it follows, I submit, inexorably from a finding that he had focused suspicion as to misuse of client money, that here there is, there should be a finding of blind eye knowledge of misuse of client money, because he must have decided to do nothing about it. He must have.
Well,
And this, yes.
Yes and no. On that hypothesis, he must have decided he wasn't going to comply with his professional obligations to follow it up and to whistleblow. But it's a further step, isn't it, to imply from that the reason why he did that was that he was afraid that if he did follow it up, he would find out that his suspicions were confirmed and then he'd have to whistleblow.
It's a small step. I take my lady's point, but it's a very small step. Because we, of course, are dealing, or the court is dealing with a solicitor about whom the very striking finding has been made at first instance that he was unsuited to be a solicitor for reasons developed by the learned judge. Now, that finding, correctly understood, does not enable Mr. Prentice to escape a finding of blind eye knowledge. In fact, my suspicion is that it supports it. It explains why, despite his knowledge of the relevant rules, he decided to do nothing about the matter, investigate, ask awkward questions, blow the whistle, when he formed, as he must have done, I submit, focused suspicion that Mr. Jones was up to no good in relation to client money. Everything fits, everything falls into place. Here we have educated, intelligent solicitor familiar with the relevant principles, but also a solicitor who should never have been a solicitor because he takes his professional responsibilities much too lightly, as the judge has found. He is a intelligent, educated solicitor with a defective or absent moral compass, to use the terminology that is used in the cases about integrity in this field.
Well, that's worse in some ways, isn't it? That finding is somewhat different from saying he takes his professional responsibilities too lightly. It's basically that he's setting the moral bar lower than most right-thinking people would.
Well,
in other words, he's prepared to regard as acceptable behaviour that which most of us would not.
Indeed, my lady, and there are occasions in this. I do respectfully submit that there are passages in this judgment which are excessively benign to Mr. Prentice, and I would make that submission in relation to the two passages where the learned judge says in terms he was unsuited to be a solicitor. He expresses himself in relatively kindly terms, but when one sets that finding in context and one looks, as we will in a moment, at the detail of certainly one of the matters which caused the judge great concern, this court, I hope, will accept my submission that what Mr. Prentice knew about what was going on was amounted to information which would have caused any solicitor with any integrity at all to say, I'm having nothing to do with this. We will get to that in a moment.
This is on Reno, is it?
It's on Reno, and specifically two aspects to the Reno saga. There's the writing of the, proposed by Mr. Prentice, the writing of the false letter in, the letter containing false statements in June 2017, which said the money is still held when plainly it was not. And then, in early to mid 2018, there is the utterly disgraceful sequence when Mr. Jones puts together his scheme to defeat the attempt by the Reno client to get the money back by asserting a lien, which was legally insupportable anyway, but let's concentrate on the facts. And there was a quite, I will show the court one or two of the relevant documents, there was a disgraceful sequence where plainly, and as the judge has found, it was evident to Mr. Prentice this is what was going on. Chargeable hours were plucked from the air in order to inflate the value of the lien by something like 200 or 250 chargeable hours, which probably equates to close to £100,000. And Mr. Prentice expressed both at the time, so far as one can tell, and at trial, expressed nil or negligible concern about what was going on. He was essentially, he was party to that because he was one of the fee earners whose hours were inflated, in his case from 6 hours to 86 hours. So the court will be seeing, I hope, the direction of travel of my submissions.
Okay, let's go back to this question of the distinction between knowledge and condemnation. Maybe I'm misunderstanding, but condemnation, as the judge suggested, and I'm not sure it's challenged, connotes acceptance or approval.
Yes.
And I can see that if a solicitor knows of something, given their professional duties, you might say, well, you can readily infer acceptance if not approval, because you haven't done anything about it, so you've accepted it. But it seems to me when you go one step back, so you don't have actual knowledge, you have blind eye knowledge. So what you have is a focused suspicion. And then you have a decision not to investigate. But is it not possible that the reason the solicitor decides not to investigate is because he doesn't approve or doesn't accept it? And that's why he doesn't want to clarify his suspicion.
Well, that would, if that would be the correct analysis in my submission, that would still qualify as blind eye knowledge.
Yes, but that's my point. We're not talking about blind eye knowledge. We're talking about acceptance or approval.
Yes.
And the point I'm putting to you is, what if the reason he doesn't, he allows himself to go blind of the events, to be blind of what's happening, is because he doesn't approve of what he suspects is happening, so he doesn't want to confirm it.
I think I would answer my Lord's question in this way. It is, I would suggest, possible to condone something without approving it. It's entirely possible to be a rather reluctant condoner. You know it shouldn't be happening. You're a senior partner.
You're accepting that it does without.
You're accepting that it does. You know you should do something about it. You don't do something about it. You may be rather unhappy.
By remaining passive, you are accepting that is potentially the situation.
It's going on. You strongly suspect. You know you should do something about it. You don't. You know that you are allowing a state of affairs to continue in which this bad thing is probably going on. You may be in general terms, a person of integrity who is very unhappy about the situation. You may be.
You just want to wash your hands of the whole thing and distance yourself
But
as much as possible.
You put the telescope with the wrong eye. You make sure you don't acquire actual knowledge of what's going on, and you hope for the best. That is condemnation.
Mr. Prentice suspects something bad's going on. So he sends an email to Mr. Jones saying, look, I'm really unhappy about what's going on here. I want you to know that I in no way approve, accept or condone what you're doing. He's still condoning.
If it ends there and events proceed in a way that means that his suspicion remains firmly rooted on what is going on, then yes, he's still condoning. But one would then get into a factual inquiry as to whether the steps that he has taken negative the influence of condemnation.
It seems to me we're moving away from the concept of a mental state of approving or accepting, and moving into a positive duty to take steps to stop or prevent, aren't we?
I don't shrink from that, because condemnation in the sense in which this court is considering it in this case is all about, obviously it's all about solicitors. And part of the relevant context, obviously, is that solicitors' principles is all about solicitors at the top of a firm, at partner level. The context is one in which everyone knows that the principals owe wide-ranging onerous duties to check to see that things have been done correctly, to react appropriately to evidence of wrongdoing, and if necessary, as my lady says, to blow the whistle.
So if you say if you have a duty to act and the ability to act and you don't, then you have condoned.
Subject to some finding of fact made on exceptional facts about the solicitor's state of mind, on unusual facts, yes, you do. In general, you do.
In other words, there's a distinction between moral approval and factual approval / condonation.
Yes. Yes.
Thank you.
I've already said, I think, almost everything I wanted to say about the assessment, the appropriate assessment, and indeed the judge's assessment of Mr. Prentice's intelligence, qualifications, and so forth. The finding that he was plainly intelligent and well educated is made at paragraph 31 of the judgment, page 131, tab 7. I place that on the transcript. The evidence in cross-examination about what you might call financial numeracy, which was based upon a particular email which showed him to have those qualities, again, I place this on the transcript simply, is at tab 72, page 386 in supplemental bundle 2, but I don't want to take up time going into that. And the evidence about his awareness of the rules and principles governing solicitors' conduct and handling of client money is in the cross-examination at tab 72, page 365. And again, I put that on the transcript, but I don't want to take up time going to it. The next very broad and short submission that I wish to make, please, is that the learned judge can be said to have, as it were, set the bar too high for my client in this case, when he said at paragraph 146 that the task of proving condonation was, quotes, a major undertaking. Circumstances alter cases. The burden of proving condonation obviously was on my client. I don't shrink from that at all. And it's very easy to conceive of cases in which that burden would be very difficult to discharge indeed. You might, for instance, have a case where there was a highly respected senior partner of a firm of solicitors, and there was a rogue at work in that firm, and the senior partner had seen one document which might have given rise to suspicion and did nothing about it, and life went on as normal. In those circumstances, it might be very difficult to prove condonation, because you would have to prove guilty knowledge in relation to one moment in time when the solicitor should have reacted differently to a particular document. And it would be very easy to see that a court would lean towards a finding that guilty knowledge had not been made out and it was just a matter of honest, conscientious oversight. But that manifestly is not this type of case. And I just make this short submission as to the starting point that the judge should have adopted when tackling the issues as to condonation. The following matters were all either completely clear and indeed common ground, or were established in the course of the trial. First, it was clear that Mr. Jones conducted the Jirehouse practice very unsatisfactorily in various ways, including misusing client money over many years, and that was clear in part from evidence that the learned judge dealt with quite a light touch from a solicitor called Mr. Young, who stayed at Jirehouse for just over 2 weeks in 2010 before making a report to the SRA, which I will go to in a moment briefly, and a solicitor who became a barrister called Ms. Strickland Coutinho, who was at Jirehouse for a few months in 2012, and who also found it necessary to make quite a lengthy report to the SRA about troubling matters that she had observed there. I didn't say at trial, and I don't say here, that Mr. Prentice necessarily knew all that material in 2010 to 2012. He was relatively junior. It wouldn't have been right to suggest that to him. But clearly, when evaluating Mr. Prentice's knowledge about what was going on and what was going wrong at Jirehouse over the years, it was necessary to pay close regard to what those two individuals, and in fact a third one called Elgood, had discovered at Jirehouse in the early years of that decade. So that's the first thing that was clearly established by the documents, and indeed by the evidence, because both Mr. Jones and Ms. Strickland-Coutinho were due to give evidence at trial, but my learned friend chose not to cross-examine, so they did not appear in the witness box. Sorry, Mr. Young, thank you very much. Remove Jones from the transcript and replace it with Young. Thank you very much, I apologise. Second matter which sets the inherent probabilities is that Mr. Jones committed a serious fraud in 2016 and acted disgracefully in seeking to avoid exposure in relation to that between 2016 and 2018. That was established, not challenged. Obviously, a third matter is that a further very serious fraud was committed in 2018 to 2019 with a similar pattern of manoeuvring in an attempt to avoid exposure and to put off the evil day. Established fact, obviously, that Mr. Prentice was at Jirehouse throughout this period. Established fact, important fact, contrary to our sham partnership argument, that Mr. Prentice became a partner in June 2017. And obviously he accepted, as he had to, that imposed additional obligations on him. Finding by the judge, clear finding, that Mr. Prentice, in certain respects, lacked integrity and had acted dishonestly. And that, of course, led to the conclusion that he was unsuited to be a solicitor. And the final contextual matter of relevance to this submission is the evidence that Jirehouse was under intense financial pressure, certainly from 2016 onwards, and in particular in the 2017 to early 2018 period. And I'll go to one or two documents in relation to that. So just taking stock and stepping back from that and seeking to take stock, my submission is that all of that material created quite a high degree of inherent probability that somebody who'd been at Jirehouse, right-hand man to Mr. Jones, and chosen to be the second partner from 2017 onwards, was really very likely over the years to have encountered troubling evidence of misconduct by Mr. Jones, including misconduct in relation to client money. Now, that conclusion could clearly have been negatived by a favourable reception of the evidence actually given by Mr. Prentice, but there were a number of matters that were pointing in the direction of an adverse conclusion of that nature. That is that submission. Then I just want to say something briefly about the question of motive, because my own friend appears to place quite a lot of weight on this point, and he says quite correctly that there are plenty of cases in which judges have made the point that when considering allegations of dishonesty, and I would add to that any allegation of serious impropriety, it is usually helpful and relevant to consider motivation. Fully accept that. But again, this is context dependent. I had no reason to put to Mr. Prentice, I did not put to Mr. Prentice, I think it would have been a very questionable propriety to do so, that he was motivated to condone what was going on because he was in on the fraud in the sense of expected to take or taking a share of the ill-gotten proceeds. There was no evidence to support that, and I did not need to put that. The contextual point that really disposes of my learned friend's submission about motive is that condonation, to condone, is not the same as to commit a fraud. To condone, as has just been discussed, all that is required is inappropriate, unprofessional inaction when one should know, when one should act, given what one knows or strongly suspects. One does not need a defined motive to fail to ask awkward questions, and it may be to take awkward action, such as self-reporting or reporting somebody else to the SRA. And that more or less proves itself, because it is, after all, it is awkward to ask awkward questions. That's why they're awkward, particularly of an individual like Stephen Jones. The question of consideration of motive and motivation is relevant in this case, but in fact it gives my own friend no support at all, but it cuts the other way in my submission, and I just want to shortly develop that point. Where the court is considering the situation of a solicitor who has failed to take certain action which it might be thought should have been taken by a professional with integrity, the court might, on appropriate facts, reason as follows, in as it were a reverse direction. The court might say to itself, well, it's a fact that the solicitor did nothing in relation to what, on one view, appeared to be going wrong, and it's a fact that one might have expected the solicitor to take appropriate action. And I'm going to come to the conclusion that the reason why this apparently highly respectable solicitor did not take appropriate action was that the solicitor, in fact, had not formed the relevant suspicion with an appropriate degree of definition and focus. Because I'm satisfied, having heard from the solicitor, that he or she is a person of integrity, and if they had formed that sort of suspicion, I'm satisfied they would have taken action. One can imagine a sort of reverse engineered analysis of motivation in that way, which would lead to a finding that the solicitor had not formed the relevant suspicion to the relevant degree. However, that type of analysis certainly does not work, would not work here, because there are two findings which tell one why Mr. Prentice would not have been at all likely to take appropriate action, even if he had formed the relevant suspicions. Two matters which are found facts and which cannot really be contested. The first is the judge's findings that he should never have been a solicitor. He was unsuited to be a solicitor. One can discuss the precise implications of that finding, but it strongly suggests that he was a person who could not be expected to take appropriate action, even if he had formed a relevant suspicion. The second, not so much a found finding, but a matter that Mr. Prentice spoke to in evidence, and which is apparent anyway from various parts of the case, is that it was conceded by Mr. Prentice, said by Mr. Prentice, that he thought Mr. Jones would resolve things. Again, I place on the transcript this transcript, the reference to his cross-examination, which is at 72, 437 to 438, 72, 437 to 438, but I won't go to the passage in the interest of saving time. I put it in this way. Mr. Prentice had reason to think, and did think on his own evidence, that Mr. Jones was some sort of Houdini who was very good at getting out of tight corners. And that explains the shock that that the judge found that Mr. Prentice felt when finally told in March 2019 that the roof had fallen in, many millions had gone, Mr. Jones did not have them and was not able to pay them back, and Mr. Prentice said that he was shocked, and the judge accepted that. He would have been shocked, but not because he had not harboured suspicions previously. He would have been shocked because finally Mr. Jones had, as it were, run out of road and had failed to resolve matters where he had always succeeded in resolving them in the past.
Which ties in with the temporary exigencies point.
Yeah.
Indeed, indeed. The final broad submission before I look at certain areas in the judgment and certain evidential matters. The final broad submission that I make goes to the what one might call the commercial context of this type of insurance and in particular the application of this particular exclusion in this type of insurance. First point, which I think I may already have made, so I'll make it very shortly, is that the court, commercial court and this court, acting with a robust grasp of commercial realities, will see that insurers are going to require some degree of protection in cases where a firm of solicitors does not merely contain one bad apple, but is corrupt all the way through partnership level, because that's the really dangerous situation. Because there, the insurer and indeed the public do not have the protection that they should have against one bad apple of other partners keeping an eye on things, observing complying with their duties under the various relevant rules. So it's a particularly dangerous situation, and it's completely unsurprising to find, therefore, the condonation provision built into the dishonesty exception. Second point I can make very shortly, and I make it absolutely clear that I'm making no such allegation anything of this nature occurred in this case. But of course, where you have a position where the entirety of a partnership, say 2 or 3 different partners, are all complicit in fraudulent activity relating to client money, it's a particularly dangerous situation for insurers because of the risk that client money might be stolen, if I may put it this way, divvied up between the fraudsters, who may involve some third parties and the partners themselves, and then a claim is made against the insurance policy and money is magicked out of thin air. It's a very attractive sort of fraud for the fraudsters, and it's a very dangerous sort of fraud from the point of view of insurers. The learned judge did not in his judgment say anything that evinced a recognition of these commercial factors, and did in fact, I don't rely on this as a ground of appeal, but it's a reason for some degree of caution about accepting certain aspects of the judgment. As the court will have seen, the learned judge allowed himself an endnote, or as it were, provided an endnote or a footnote to the judgment, in which his lordship expressed surprise that the rules were structured so as to allow insurers to walk away.
I'm not sure that's an entirely fair...
Is that unfair, my lord?
I think what the judge says is, the point is for discussion, but I think it may surprise the client community.
Yes.
And the public. I don't think he's expressing surprise.
No,
I think what he's saying is, and I think it's a point which is maybe fairly made, that when people deal with solicitors, do they realise that if in fact all the partners are involved in the dishonesty, they won't get any benefit of insurance? And I think that's all he's saying.
Yeah.
I do take that point, my lord. If I do see that, but perhaps blatantly, I see that reading. So one might read that as simply indicating that the judge wished the regulator to consider whether this contractual position should be made more transparent, more clear to members of the public.
Yes, I think for myself, the judge has very deliberately done it as an endnote, and I wouldn't have thought one could read this as feeding into his analysis of of the meaning of the provision at all.
No,
I mean I think it's quite clear that the analysis is that the fraudulent partner has no insurance cover. So the starting point is you have to find an innocent partner to be insured.
Yes.
And so if you can't find an innocent partner, you haven't got insurance. And that's your answer to it, and seems to me is nobody can be particularly surprised by that if they understand the policy. I don't think, no, that's the point the judge is making.
I do not seek to.
I think,
Speak
I do
against that.
think, for my part, particularly given what you said about timing, it's really important we get into the detail.
I'm going to go straight there.
Because you're trying to persuade us that the judge, on the material before him, reached the wrong conclusion, notwithstanding that he saw Mr. Prentice give evidence. And he reached certain facts, certain conclusions, such that he says if he had been aware, if Mr. Prentice had been aware, had serious, focused suspicion, he'd have left, he says. And he didn't leave.
No.
So that he doesn't say he would have made an SRA report, but he says he would have left.
Yes.
So in a sense, he did reach the sort of conclusion which you say somebody might have raised as to support a finding. So you've got to undermine that finding.
Yes, and maybe the moment for a short break, but in a sentence or two, I will give advance notice of one point I make in response to what the learned judge said about Mr. Prentice being too, as it were, risk-averse and self-protective.
Yes.
To have allowed this situation to continue in circumstances in which he did have some form of knowledge that really bad stuff.
And he wanted to become a partner, he says.
Indeed.
If he had known that things were so bad.
I'm going to make one, just by way of advance notice, I'm going to ask the court to consider whether that evaluation of Mr. Prentice is sustainable,
Yes.
given the personal risks Mr. Prentice knowingly took
Yes.
by committing very serious misconduct on 2, 3, or 4 occasions.
A fabricated letter.
And then by perjuring himself.
Yeah.
Well, we'll come to that.
Yeah. But we're going to have to, in detail. And I was wondering to what extent you're going to show us transcripts of Mr. Prentice's evidence.
To some extent, my lord, and it may be. Indeed, indeed.
Did you say you wanted to break before you start on that?
I think the transcribers asked for 5 minutes, and this is probably about the right moment.
Yes, so 5 minutes. Thank you.
over that little issue. Probably haven't looked. Take it from there. Well, can I then really begin my analysis of the evidence and the judge's treatment of it by going to the judgment at page 132, paragraph 38, and the section which is headed Early Financial Issues within the Jirehouse Entities Early SRA Investigations.
Yes.
And there the judge correctly records that Mr. Young's witness statement was not challenged and therefore he was not called to be cross-examined. And he was the solicitor who was there for just 2 weeks. If I may, I'll quickly show the court his report to the SRA. It's the first document in Supplemental Bundle 1, tab 1. So Supplemental 1, tab 1, page 1 indeed. Mr. Young's letter to the SRA, 7th of April 2010, begins by making the blunt point that he was only at Jirehouse for 2 weeks and 3 days. And he nonetheless has taken the view that he's under duty to report certain matters, and he summarises them in this letter, and the court will see what is said there. I won't read it all out, but the first point relates to a failure to carry out proper client reconciliations and the possibility, not evidenced, that documents may have been created to allow reconciliations to take place. Second, an understanding that transfers of client money had been made without client authorization or other proper reason, serious breach obviously of the accounts rules. And third, as early as 2010, the companies appear to be in severe financial difficulty, with bills being issued on a day-to-day basis with a view to meeting cash flow needs of the companies, etc. Some more is said about financial difficulties. don't think I need take up more time with that letter. It wasn't challenged that Mr. Young had formed those concerns after his very brief period at Jirehouse. Paragraph 40 of the judgment refers briefly to Ms. Strickland Coutinho, then a solicitor, now a barrister. She was there for longer, a few months, and she made the report which we have at tab 3 in this bundle. Page 13, tab 3, page 13. And I can go, excuse me. He speaks of concerns about solvency. I'm on page 15. So there are continuing financial pressures during this period. At page 16, she expresses her concerns a third of the way down the page about a certain project involving a building purchase, with the business being owned partly by an unnamed client who would have, presumably, would have a share of just over 50% and the remainder by Jirehouse Interests. She says there was uncertainty as to whether that meant Mr. Jones personally or other investors brought together by Mr. Jones. She continues her discussion about that. A little lower down, she records that Mr. Jones defaulted on repayment of a loan made in that respect. And she says, fairly enough, 6 lines up from the foot of the page, the above would appear to be a breach of the conflict of interest rules, etc. And I may show the court this later or very swiftly tomorrow morning. There was evidence from Mr. Prentice about the risk that Mr. Jones was acting in situations in which there was a conflict, clear conflict between his own interests and the interests of clients. Over the page, page 17, Ms. Strickland Coutinho told the SRA about her concerns about lending between entities, and much that was clear in relation to that. I pass over the observations about a misuse of company funds, which involves misuse of credit cards and so forth. That does not seem to me to be directly material. On page 18, she continues her discussion about problems in relation to conflict of interest, as the court will see, page 18.
Well, the real meat of it really is on page 20.
And 20, my lady, indeed, well, she was ahead of me again. It's improper use of client funds, and what she says at page 20 in that section there is a foretaste of matters that we're going to see in sharper focus later on.
Do we know who the former colleague is?
We don't know.
And what you didn't show us, but we'll probably note, is that there was an SRA report, tab 2, which said no cause of concern identified at the firm.
Indeed, and I didn't show you all of that, but I was going to note and concede that a point that could be made on the other side of the case is perfectly fairly, is that the SRA looked into this firm on a number of occasions, including at a very delicate point in late summer 2017.
Yes.
Just after Mr. Prentice had been made a partner.
Yes.
And did not at any point appear to come to an adverse finding about.
Yes, which was a factor the judge referred
took into account and was entitled to do so. I don't.
Can I understand the report following Mr. Young's report is at tab 2. Where do I find the one following Ms. Strickland's report?
Her report is at tab 13. Sorry, tab 3,
Yes.
page 13.
Yes, and where is the SRA's response to that?
There is a response, certainly referred to at tab 4, page 22, an internal Jirehouse circular, which records in the first line that certainly an investigation has now been concluded with no finding of fault and no need for further action. And certainly I'm not aware of any evidence that the SRA, as I say, took any action in relation to the matters that were reported to them in 2010 and 2012.
So this went to Mr. Prentice?
Yes.
Right. And is there any evidence that the report of 15th of July (2010) that went to members of the firm, or the result did?
I'm sorry, well, went to members.
Well, we can see at tab 4
Yes.
that the result of the SRA investigation was reported to members of the firm, and including Mr. Prentice.
Yes, indeed.
And it seems to me that's quite important, isn't it? Because it might be said that is an antidote to any concerns which were raised by Ms. Strickland.
Certainly, and as I've conceded, my lord, it's a fair point
Yes.
to be made.
My question to you was:
Yes.
Is there any evidence that the report, the 72-hour report, also was communicated to Mr. Prentice?
Not that I recall, am aware of.
I mean, forgive me, but if we're going to look at the evidence to attack the judge's conclusion, one has to understand what it was. And showing us the documents, we have to understand them in context.
Indeed, Lord. I go to these the 2010 and 2012 reports,
Yes.
which would have been spoken to and proved in evidence, as it were, and the matters underlying them would have been proved in evidence by the individuals who made those reports, and they were proved by their witness statements and would have been spoken to in the witness box. I go to them in order to establish in broad terms what was going on at Jirehouse at that stage, which did already involve significant misconduct on the part of Mr. Jones, judging by what one reads there.
Well, I don't know. I'm not sure one can say that, because we have the SRA on each occasion has said there's nothing to see here.
Well,
How can one go behind that? And certainly, how could... I mean, I thought it's exactly the opposite. Complaints are made, and the SRA says we don't find any problem. I'd have thought, actually, an honest solicitor would be reassured by that.
I accept that an honest solicitor could have taken a degree, maybe a significant degree of comfort from the SRA's, as it were, nil return in response to these reports. I do accept that. They are a start, but they are by no means
Yes.
an end. Those were early days. The loan judge deals with those reports in the section that
Yes,
I've turned up in the judgment.
indeed.
And then in this section, paragraph 46 onwards, deals very briefly with what one might call the cash flow issue. The evidential position in relation to financial problems at Jirehouse was strange. Mr. Prentice said in terms in his first witness statement that while there had been from time to time cash flow issues, they were neither persistent nor pervasive. And he stuck to that evidence. I'm sure my own friend would agree. He stuck to that evidence like glue throughout his cross-examination. He refused to make any concession, any further concession, about the existence of financial pressures. As I shall, as the judge accepted, and to some extent, and as I can demonstrate, and may have to demonstrate, there was in fact a very considerable quantity of evidence showing the existence of severe financial problems, resulting in the revenue sending the bailiffs around in late 2017, in Mr. Prentice writing plaintive emails saying, "What's the plan? I can't even pay my bills," meaning I infer his personal bills, etc. We can look at those to the extent that we need to. My learned friend, Mr. Flenley, conceded in oral closing submissions that what Mr. Prentice had said in his witness statement about financial problems was not correct. And in fact, the learned judge immediately asked my learned friend quite properly, well, what conclusion should be drawn from the fact that Mr. Prentice had misstated the position in relation to financial problems. Our submission is blunt in relation to this. His attempt to understate the degree of financial pressure at Jirehouse was clearly a lie. There were major financial problems over a long period of time, of which he would have been fully aware.
But that's contrary to the finding at 48.
Yes, and this is an area where we criticise, with respect to the judgment, for failing to deal sufficiently comprehensively with the evidence. And may I just explain how that submission works? This short passage at 46 to 50 appears in a passage in the judgment, a section in the judgment, which is dealing with the early period, the 2010 to 2012, maybe to 2014 period. Principally, there is a brief reference at the end of paragraph 47 to November 2017, but nothing more than that. The problem with the judge's treatment of this point is that the bulk of the evidence, which showed very acute financial problems that would have been very present to Mr. Prentice's mind, concerned 2017, late 2016 through 2017 into 2018. And reading the judgment as a whole, it's a fair criticism that the judge has failed to set Mr. Prentice's evidence and actions and inaction in 2017 to 2018 properly in context, because he has failed to record and consider and evaluate the evidence about financial pressure in that period. And that will come into very sharp focus, I hope, in a moment when I get to the relevant passage about Reno. At any rate, that's...
Does it matter what the judge found about the early stages if your real criticism is that it would have been blindingly obvious to Mr. Prentice that there were severe financial pressures in 2016 onwards, then does it matter what the judge found in 48, 49?
I wanted to... it matters less than the findings about 17 to 18, I agree, my lady, and I wanted to set the context by going to the 2010 and 2012 reports, but I now want to move on fast to the critical period, which begins in late 2016 and then moves to June 17 when Mr. Prentice becomes a partner and moves on from there.
At some point you're going to talk about these emails, I hope.
Yes. When it says these emails, does my lady have particular emails?
Well, it's your case, Mr. Lawrence,
Indeed.
not mine.
Indeed, I'm going to go to some emails. Page 134, a short section, paragraph 51 to 55. I simply note this. I don't want to take up time with this. This is still the period before Mr. Prentice became a partner. This is late 2016, and I don't need to do more than remind the court that at 55, the court accepted criticisms that I made in extended cross-examination about Mr. Prentice's handling of two winding up petitions against a Jirehouse company. It wasn't one of the legally regulated Jirehouse companies, but it was a company very close to the centre of Mr. Jones's operations called Jirehouse Capital Finance, and it was the subject of two winding up petitions. Mr. Prentice was tasked with fending off those winding up petitions. In doing so, he produced, as the judge said at paragraph 52, some draft audited accounts which bore no relation at all to the accounts that were eventually prepared and whose provenance was not satisfactorily explained, as the judge found in paragraph 52. That was unsatisfactory. There were other matters that were unsatisfactory. I needn't take up time with this because the learned judge found at 55 that Mr. Prentice's conduct in relation to those winding up petitions was deeply unprofessional and was not honest. So there I have, as it were, in our favour in this case, a clear finding of dishonesty at that point.
Well, it goes further. It's the
Yes.
next sentence, surely. It showed he was willing to go to considerable lengths for Mr. Jones.
Yes.
Asserting solvency when he had insufficient grounds for supposing that it was solvent, and was himself suggesting that it wasn't, because he wouldn't be telling his principal to put it into an insolvency process if he believed it to be solvent.
Indeed.
So he's prepared to lie on behalf of Jones to cover up a financially impecunious situation in relation to one of Jones's companies.
Indeed. Indeed.
Right, so now you've got a finding by the trial judge that this solicitor is prepared to go to the lengths of dishonestly misrepresenting a situation in order to cover up for his principal.
Yes, and to cover up for his principal and to fend off insolvency proceedings which could have a very embarrassing outcome for his principal, who had guaranteed, to the tune of over £1 million, given a personal guarantee in relation to a debt that it appears could not be paid at the time. That's what was going on, and the question, of course, is how does that sit with? Is that reconcilable with the key finding that the learned judge made, to the effect that Mr. Prentice could not have had the sort of guilty knowledge represented by guilty blind eye knowledge derived from a focused suspicion as to misuse of client money. He couldn't have had that because he would have been out of the door. He would have regarded it as too risky.
Well, what we've got here is actual knowledge that the company is insolvent because he's suggesting it should be wound up. It's a different company, the Jirehouse CF. Actual knowledge.
Yes.
And lying about it.
Yes.
Saying that black was white.
Absolutely. All for at that point, Mr. Jones, the man running Jirehouse.
When he's not a partner yet.
When he's not even a partner at this stage, but he's doing all of that in late 2016. Maybe that was, as it were, part of his job application in spring, summer 17 when he becomes a partner. But that is what is going on in late 16. So there's a dark cloud of apparent insolvency recognised by Mr. Prentice because he was talking to Mr. Jones about putting the company into liquidation, and wholly improper and dishonest actions taken by Mr. Prentice to protect the Jirehouse and to protect Mr. Jones. That's what's going on there. So that begins to set in I hope sharp focus the context in which the learned judge should have considered and had to consider what did and didn't happen and what was and was not done by Mr. Prentice in 2017 and thereafter. Then over the page, at paragraph 59, the judgment turns to what is referred to as the Reno matter, and the court will have picked up certainly something I know of what all this was about, but it will assist, I hope, if I take the court to some, not many, but some of the documents which illustrate what was going on. One can pick up the story before there's any evidence that Mr. Prentice is directly involved, but it's the starting point, by going to Supplemental Bundle 1, tab 8. tab 8, page 46. Here we have Jirehouse, and that's Mr. Jones's signature, I believe, Jirehouse writing to a client or counterparty called Confiance Limited. It's all concerned with a dispute between two individuals called Anderson and Wilson. And what in summary this letter is saying is that a good faith payment of £400,000 is to be made, and the monies will be held on the terms set out at the bottom half of the letter at page 46, namely, will be held pending settlement in client account, and at the top of page 47, the further terms are set out. On completion of settlement, the funds will be applied towards settlement as the new trustees shall direct, and if settlement does not take place, the funds will be held and applied towards resolution of the disputes between the parties as directed by the parties or by order of the court. So it was an arrangement, a sort of escrow or stakeholder arrangement, whereby the solicitors agreed to hold £400,000 on those terms. One immediately wonders how it can ever have been thought conceivable that a lien could be exercised in relation to a money held on terms of that nature, but as we shall see, it was. Mr. Prentice, no evidence Mr. Prentice was involved at that point, so I don't thought none of illusion about that. But if one then, the court would then turn to tab 12, please. We've now reached, at tab 12, we've reached February 2017. The winding up petitions that we have been discussing, I've been making short submissions about, have been presented in late 2016, and they've led to a problem which is described by Mr. Jones in an email to Mr. Prentice at page 83, second page of this tab. Mr. Jones writes on 10th of February, V, as discussed, Confiance, Trust House in Guernsey, sent the client, whoever that may be, into a tiz when they discovered the winding up petition was issued. They thought it was against the legal practice. It wasn't. It was against a different Jirehouse company. Please let me have a short summary. And then Zoo, that's Ms. Tote Ava. Please can you let me know as soon as possible the amount of funds we are holding for Confiance JT client account and so forth. And then I read on, we are in very dangerous territory and our reputation could be shot over this. So far I have contained it, but we have only the weekend to shut it down. So danger is in the air. And Mr. Prentice gets that email and responds shortly, as we see at page 82. So he is, as it were, on the documents, he is being introduced to the Reno problem or the Reno issue at this stage. What then happened, as was proved at trial, is that in late February 2017, there was a window dressing exercise which involved the Reno monies or an equivalent sum being restored to Jirehouse's client account. And that was a window dressing exercise in the sense that it was designed to create documents which would persuade third parties that monies were being properly held. I needn't go to those documents because that arrangement is the subject of an express finding at paragraph 60 of the judgment. Then one moves on to June 2017.
Sorry to interrupt you. Is there any evidence that Mr. Prentice knew about the window dressing exercise? I ask because if you look at page 83,
yes,
in the part that's addressed to the female employee, she's asked, can you let me know ASAP the amount of funds we're holding for Confiance brackets JT client account, in which case confirm to which Jirehouse bank account these funds were actually transferred?
Yeah, my lady, yes. The short answer is no. There was and is no evidence that Mr. Prentice had actual knowledge of the window dressing exercise in February 2017, and he said that he did not, and we did not. We were not able to contradict that. However, he does acquire more information, more knowledge about Reno as time goes on. If the court would turn to tab 14, we see here Mr. Jones, who has, within the last 2 or 3 weeks, made Mr. Prentice the second partner at Jirehouse, emailing him as follows. See attached, that's a reference to a letter in, I think, from the client chasing the money. See attached, there is an agreed consensus approach to this that will result in our fees getting paid, about £325,000, but we need to run a very tight legal line on it. Our bottom line is that we have a lien on all the funds against our fees, and we have fee agreements in place for everything. I think we should simply put in a holding response for now to show willing. We have to pick up where we left off with Zoo in September, October last. Mr. Prentice was asked about that, and he said he had no recollection of any earlier dealings with Ms. Toteava about Reno. So he's, as it were, brought into the loop on the 12th of June. Then, if one turns to the next tab 15. This is a sequence of emails from June 2017, and one needs to start at the end at page 92. This is an email from Mr. or Ms. Udin to Mr. Jones and others, not to Mr. Prentice, saying, 2nd of June, saying, Jirehouse requires a netting agreement for the Reno loan on JSBF books. JSBF was a Jirehouse entity that stood for John Street Bridge Finance. And the email goes on, currently JSBF owes Reno Trust £408,000 odd as per attached statement. And there's a further reference to a remaining amount to Reno Trust being a smaller sum. We are in process of closing the year end and need the agreement in order to adjust the loan accounts. This is the first document which refers to something that was obviously inconsistent with the Reno money being held safely on client account, namely the concept that Reno had made a loan to a Jones entity called John Street Bridge Finance. This sequence of emails then continues. If one goes to page 90, there's a further email, 7th of June, in which Mr. or Ms. Udin makes a further reference to the said purported loan by Reno Trust. And then at page 89, start of the tab, Mr. Prentice appears in the list of recipients, and the email at the top of the page, which would be around mid-June, it's not dated, is from Mr. Jones, and it says this: V is dealing with, something's been redacted, and the request to return funds, which must mean Reno, and the netting off of our fees generally. So Mr. Prentice is now being brought into the matter and being asked to deal with it. The judge deals with this sequence of emails at paragraph 61 and 62. And what was put to him, of course, was that read as a whole, the emails were not consistent with the Reno monies being safely held on client account. At 62, the judge says this, that Mr. Prentice contended in his evidence at trial that he did not read down the email chain at the time. I do not accept that that was the case, but I do accept that he gave it little attention. That's a rejection of his evidence that he didn't read the email chain, and unsurprising because it's likely that he did, and it's hard to see how he can have remembered, as it were, not reading it. And an unexplained finding that he gave it little attention. At paragraph 63, the judge records a point that we made, that the fact that Mr. Prentice was being brought into the loop showed that Mr. Jones was not seeking to conceal indications that monies had gone from the client account, and he said that he accepted that point, but not that Mr. Prentice reached any conclusion from the email chain about whether monies were in the client account. That finding, with respect, is not a sufficient finding to deal with what was really an issue here. The question was not, did at this point Mr. Prentice reach a clear conclusion about whether the monies were held in client account. The principal question was whether he was receiving evidence, coming into possession of evidence, which caused him to form a strong suspicion that this was a situation in which the monies had gone. That's what was being put to him. Then at tab 17, the saga continues with a letter substantially drafted by Mr. Prentice to Reno about the sum of £400,000 that was not being repaid.
Where do we find that?
Tab 17, my lady. And this letter contains quite a lot of rather legalistic material, but for present purposes, its importance lies in the fact that it contains two statements that are false or at least misleading. First, in the second line, it is said that it was necessary for us to review our records before responding to Reno's letter, and this took some time. Mr. Prentice did not say in evidence that he had been party to any review of records, and of course a proper review of the firm's records would have revealed that the money had gone. That was common ground at trial. Then, one paragraph down, just below the middle of the page, one sees a direct misstatement. As you are aware, the basis on which the good faith sum continues to be held by us is set out in a series of correspondence between us. That was false. The money had gone. It was no longer held on client account. Mr. Prentice was asked a lot of questions about this, and in his witness statement, he had said that he had been shown an internal accounts document by Mr. Jones, which demonstrated that the monies were still held on client account. So he gave that evidence in an attempt to justify the making of what can either seem to be a false statement to the client about the monies being held. The judge was taken at trial, and Mr. Prentice was taken at trial in cross-examination, to a number of documents which strongly indicated that Mr. Jones was not attempting to keep the fact that the monies had gone in a secret in any way. And two or three of those documents came to Mr. Prentice's attention, and there was extended cross-examination on those points. That caused the judge to make the findings that we find at paragraph 67 onwards in the judgment. Paragraph 67, Mr. Prentice has sought to justify the false statement in the letter that the monies were held on client account by giving evidence that he was shown an internal accounts document by Mr. Jones and a member of the accounts team. He accepted the proposition put to him that if this was so, then this involved Mr. Jones in preparing a forged document in order to deceive him, and so on. Paragraph 68, the judge explains why Mr. Prentice's evidence is improbable. And then at paragraphs 71 and 72, the judge makes important findings. First, he finds that Mr. Prentice was the draftsman of the false letter, and he finds that Mr. Prentice made no check on the true position when drafting the letter. He left that to Mr. Jones and did not concern himself with whether it was true or false. at 72, consistently with his not concerning himself with whether the letter was true or false, I find that he was not shown and did not ask to see an internal accounts document. So that evidence was made up. And the judge accounted for that by observing that Mr. Prentice had realised how serious it was to have drafted the letter in its terms and circumstances without checking on the true position.
How do you reconcile that, sorry to interrupt you,
Not at all.
with a finding that he's read, although not paid a great deal of attention to, an email which makes it blindingly obvious that the money's not in the client account?
Exactly, my lady. The finding that Mr. Prentice was unconcerned with whether the matter was true or false, and these findings generally are not reconcilable with the express finding that he had read the email which showed that the money had purportedly been lent by Reno to a Jones company.
Once you accept that he's read that document, even a cursory reading of that document, you'd realise the money wasn't in the client account.
Yes.
So
Yes.
you add that to writing a letter that suggests that it isn't, which is a barefaced lie. You add to that concocting a story about being shown a document that suggests that the money is in the client account. You ask yourself, what possible reason would he have for making that up? The answer to that is because he knew jolly well the money wasn't in the client account and he's trying to cover his tracks.
He was covering his own tracks.
And that's not a question of turning a blind eye. Absolutely deliberate dishonesty.
Yes. And it was the lie about the accounting document was a carefully considered lie. It appeared carefully set out in his witness statement. And then, and this with great respect, the judge, is a matter the judge did not give sufficient weight to. Mr. Prentice dishonestly, it could be said cynically, pursued a deliberate policy of sticking like glue to anything that he had put in his witness statement, even when it was demonstrably untrue. So he created this false story in the witness statement. People do these things, they shouldn't. But then he stuck to it. He perjured himself on oath in the box by indeed seeking to elaborate his account that he'd been shown a document that supported what had been said in the June letter. So I do submit.
Is this leading up to a submission that paragraph 74 is unsustainable in the light of the documentation?
I'm sorry, lady.
Is this leading up to a submission that the findings in paragraph 74
Yes.
are unsustainable in the light of the contemporaneous documentation?
My lady, yes. The unsustainable is indeed. It's really that is the first paragraph that I have marked with an expression which conveys that I intend to submit that is wholly unsustainable given the earlier findings that have been made. The what you might call the exoneration or quasi-exoneration of Mr. Prentice on the basis that even though a more competent and professional lawyer might have done something different, he still didn't know that the monies were not held by Jirehouse, is incoherent and unsustainable. He was competent. He knew the rules, but he decided not to comply with them. And even if he did not have actual knowledge, which he did, that the monies were not held by Jirehouse, he certainly knew enough to have formed a very focused suspicion that that was the case. And he had, at the very least, blind eye knowledge, but the robust and more realistic conclusion is that he had actual knowledge, and that was put to him. And then, paragraph 75 is the first occasion, but not the last, on which the learned judge, as it were, putting it colloquially, lets Mr. Prentice off the hook on the basis that if he had been asked to do something really bad in relation to these missing monies, he wouldn't have done so because it would have carried too much risk for him personally, and he would have refused.
Prepared to forge documents.
Indeed, my lady, he was prepared to forge documents. He has shown himself prepared to perjure himself. He was prepared to participate in the wholly dishonest inflation of a bogus lien. If he's prepared to do all of that, and if he's prepared to come to court and tell a number of big lies and stick to his dishonest story, then it is a very small step to conclude that he would certainly be prepared to refrain from asking awkward questions in order to help Mr. Jones continue on his dishonest path.
Well, again, we're back to the lies told over the winding up. On the one hand, he says to Mr. Jones, before he's a partner, the company's insolvent, we're winding up, severe financial difficulties. On the other hand, he's saying, in order to assist Mr. Jones, saying to a third party, company's solvent. And that puts him at potential risk if he's found out. And it's a similar sort of risk, isn't it?
Yes, absolutely. It is. There is the next section of the judgment from 76 through to 84 is headed further SRA investigation in 2017, and again I have to make the same modest concession that I have already made in relation to the earlier investigations, namely that it's a fair point on the other side of this case that the SRA investigated and took no disciplinary action of any sort against the firm. Why that was is a matter for conjecture, but that certainly was the case. The problem, put shortly, the problem from Mr. Prentice's point of view is that it was demonstrated at trial, and I don't believe this to be disputed, that the documents that were put together by Mr. Prentice and Mr. Jones and others to be shown to the SRA investigator included client account documents which were wholly inconsistent with the notion that the Reno money was being held on client account. That was, in substance, common ground at trial. What that shows is that Mr. Jones was entirely happy to go before the investigator with Mr. Prentice, because they had a tripartite meeting, two partners and the investigator, with documents on the table showing that to be the case. He wasn't worried about that at all, and is also consistent with the case being advanced about Mr. Prentice's knowledge at some level of the fact that the Reno money had gone. I think want to say more about the SRA investigation. It's not central to the attack on Mr. Prentice's position that I am developing. Then at page 138, paragraph 85 through to 92, there is a short section headed late 2017 into 2018, and this is a period in relation to which, if I may, I will show the court a certain number of emails which should be sufficient to give the court the flavour of what was going on at Jirehouse in terms of financial pressures, and also in terms of a risk that client money was being used to pay Jirehouse's bills. And one can pick up the story in, moving on the file, in supplemental bundle volume 1, supplemental 1, at tab 28. This is a relatively innocuous, relatively anodyne starting point. This is an August 2017 exchange of emails involving Mr. Prentice, involving a payment that has to be made, and it is to be made from what are called barleycorn funds. And the suspicion that might have generated, and was discussed with Mr. Prentice, was that that was being paid from client money. Well, I can move on move in fact back from there and go back to tab 27. And there are a number of emails in this tab which are revealing. If we can begin at page 143. Ninth of November 2017. Mr. Raval from the accounts team is emailing the two partners, Jones and Prentice. Hi, Stephen and V. We are being threatened by HMRC of taking control of goods. Please find attached letters, and so on. So HMRC are knocking on the door, as it were. And then if one goes back one page to 142, there is an email at the foot of the page setting out outstanding amounts of PAYE, etc. And Mr. Jones, not copied to Mr. Prentice, characterises the situation as a crisis. Thanks, he says, we need to deal with the crisis. And if one turns back 3 pages, Mr. Jones has made an inquiry of the accounts man, Mr. Raval, at page 139. This concerns the revenue's attempts to get PAYE and national insurance paid. And Mr. Raval reports he was enforcement officer and the lady called was from debt collection department. She was aware of his visit and said they will keep calling until this is paid in full. So there's heavy pressure in November 2017. Then if the court would kindly turn to tab 33. Page 159. Mr. Prentice to Mr. Jones, Mr. Raval, plaintiff email, 27th of November. Could you let me know what the plan here is, please? I really need to pay some bills. Please let me know. Back one page to 158, answer from Mr. Jones, V, how much are you down at the moment? 157, £3,500 odd is due to Mr. Prentice, presumably as partners' drawings or receipts or entitlement. And answer, Mr. Jones responds, we are pulling in cash now for salaries and God willing, we will get there. These things do happen, but that's an unusual sequence of emails from one partner to another. Now, insofar as money was being made available, where was it coming from? If the court would turn, please, to tab 34. Page 162, th of December, Mr. Jones to Mr. Prentice, V, we will be able to pay tomorrow for sure, even by this afternoon. How do we deal with, expresses himself in rather indelicate terms. My concern is that even if we pay, he will still report. That must mean to the SRA. Foot of the email, I think we can move the funds via our client account from the Blue Mango account to his account, but I would prefer just the Blue Mango account. We just need it closed off fast. Suggestive of, at the very least, a cavalier approach to client account. 161 response from Mr. Prentice.
So, afraid
What is the Blue Mango?
that's just a bit too fast for me. Move funds via our client account from the Blue Mango account. What does that mean?
To his account, it was Blue Mango appeared at trial. I wouldn't claim the evidence was crystal clear to be a client of the firm of some sort, and I can't, I'm afraid, elucidate that further.
But are you suggesting that this evidence is that monies that should be in a client account were being moved inappropriately?
On the face of it, these emails concern some form of claim against Jirehouse itself, which needed to be met. One can tell that from the title, the heading to the emails. And if your lordship would go to 161, that also talks about a payment from client account. Hi, Stephen, says Mr. Prentice. I just wanted to check where we are with funds. They will look like idiots having settled and received funds going to the SRA. I don't think it matters if the wire is made from our client account, ostensibly on behalf of Blue Mango, as opposed to from Blue Mango directly. It's all rather opaque, but there are troubling references to payments being made from client account in relation to Jirehouse liabilities, which is something that clearly cannot be allowed, should not be allowed to
Why
occur.
would money be moved, whatever Blue Mango is, whether it's another client or not? You wouldn't be using client account monies to settle a liability on the part of the firm, as opposed to a liability owed by Blue Mango to the person who's pressing for the money.
Indeed. You should never use client account money to settle firm liabilities.
But on 160, it says at the bottom of the page, let's pay from Jirehouse client account with funds sent from Blue Mango is consistent with the order. I think unless we know what the order is, I don't think we can. I mean, were these monies which were in some way due from Blue Mango?
That's what I was thinking.
I cannot pretend, my lord, that we have complete clarity as to the matters that underlie these emails. They, on the face of things, they contain troubling references to payments being made from client account in relation to firm liabilities, but I cannot go further than that.
Why does it? Why in respect of firm liabilities?
I'm sorry.
Why in respect of firm liabilities?
Because of the heading to these emails, somebody and Jirehouse urgent. It appears to be a claim of some form against Jirehouse.
I mean, is it? What it suggests to me was that, and the references to reporting to the SRA, is that Jirehouse may have given some form of undertaking in relation to monies owed by, held by Blue Mango for the third party.
I'm sorry to interrupt, my lord. It may be that I can assist. In my learned friend, the annex to his amended defence, Core Bundle, tab 11, page 231, he pleads that Blue Mango Investment Holdings Limited, called Blue Mango, was a Jones company.
It may be that I would be well advised to move on from Blue Mango. Can I show the court if I can clarify that overnight, I will do so. Can I show the court the further emails involving...
Well, if I may just say,
yes.
I mean, this is classic island hopping now, isn't it? And I think it's a real danger when we're going back and picking over documents to say a judge got it wrong.
Yes.
When we don't actually have... I mean, this seems to me, having looked at that, I cannot see that this evidence is monies being moved from a client account to discharge the firm's own liabilities, the salary or otherwise. And I think it slightly highlights the danger of the exercise that we're engaged in.
Certainly in relation to that last... I accept your lordship's gentle rebuke. There was a flavour of a hint of island hopping in relation to the Blue Mango material. The general thrust of what I'm submitting in relation to these emails is that there was a wealth of evidence of financial pressure on the firm in late 17 and early 18.
Well, and also the other way in which all of this is island hopping is that plainly each of these matters were put to Mr. Prentice during cross-examination. He gave an explanation, and in a number of the cases, the judge has accepted that explanation. But again, we're not seeing it. By definition, we didn't hear it. We're not even reading it, and yet we're being asked to say that the judge got it wrong when he rejected Mr. Prentice's explanation. And I think that, again, is an extremely dubious exercise. I'm not saying you shouldn't show us the documents.
Yes.
But we do have to remember that that's only part of the story.
My lord, I accept that, and I need to be, and I will try to be, I need to be alive to the danger of island hopping in relation to this material.
Yes.
And I will try to achieve that. The final set of emails in this sequence may well be that this rightly attracts the same rebuke, but I will go to them very briefly, are at tab 35. And they show continuing pressures into 2018, February 2018, if one starts at page 166. Email passing between the parties we have already met. That email refers to, among other things, Mr. Prentice's remuneration being partly unpaid and other debts that have not been paid. And then I think one can move to page 163 just to get the flavour of what is going on here, and very much mindful of my lord's comment. Page 163, Mr. Jones to the accounts man, Mr. Raval, Mr. Prentice. Thanks, Shani, he says, we need to clear off V tomorrow with the client 3 funds, but there will also be a further £5,000 from client 2 that should be in by now, and we could use this. This material, even given the danger of island hopping, which has to be avoided, in my respectful submission, gives the flavour of A, the acute financial pressures on the firm in this period, and B, at the very least, rather loose arrangements that seem to exist as to movements of money from client account in relation
But
to...
why client account?
Well, from client 3 funds looks to be a reference to funds to which a client is entitled. But those
Well, there may
funds...
be fees being paid by a client.
That was Mr. Prentice's explanation. If you look at paragraph 90, he said he thought it was a reference to fees.
Yes, he did, and he was asked about that. And
So the judge has actually said, I'm wary of reading too much into the receipt of these emails.
Yes, indeed.
And he says so because there's an incomplete pattern of documentation. Why isn't that a position that he's entitled to take?
Indeed. I thought it right to show the court that material. I may have misjudged, but that's the material the judge had in mind in the section of the judgment that we have been looking at.
Well, I think in order to get off the ground that this is evidence of wrongdoing, I think we have to have some indication that the monies we're talking about were client monies, rather than funds being received from the client in payment of a bill. And short of that, you know, for solicitors to be emailing each other about pinching client monies to pay fees would be absolutely extraordinary. No, I mean, maybe you say that's what happened, but I'm not sure we can read it that way. Well, and the judge didn't either.
The judge didn't, certainly.
No. I have some sympathy with him with that.
May I go? I've sought with greater or lesser success to set the scene in relation to what was going on in terms of the movement of money and financial pressure in late 17 and early 18.
Yes.
Then the Reno matter comes back into focus both in the judgment and in the documents in the section starting at paragraph 93, where the judge begins his account with a document dated 21st of February 2018, which unquestionably demonstrates that by then Mr. Prentice must have been aware that the Reno monies were not safely held on client account. That is at tab 36 in supplemental 1. page 167, tab 36, 167, Mr. or Ms. Uddin again, to various various people at Jirehouse, and it reaches Mr. Prentice at the top of the page. The email at the foot of the page refers to $416,000 being owed to Reno by JSBF. There was a netting agreement, whatever that may mean, may relate to fees. And then at the top of the page, addressed to Mr. Jones and Mr. Prentice, hi both, please see attached and email below the account details which I believe are required for your draft of the WP letter V. Mr. Prentice was asked what that WP letter might relate to, and he could not recall, but he's clearly being asked to do something in relation to the Reno matter, and he is being informed that the situation is that Reno purportedly is owed money by John Street Bridge Finance. The judge deals with this evidence about actual knowledge in February 2018 at paragraphs 93 to 94 in the judgment, and it's just worth looking at those paragraphs and seeing where the judge went with this evidence. Paragraph 93 refers to the email I just looked at. Paragraph 94, Axis contend that the fact that Mr. Prentice accepts that he was aware of this email as he did is further evidence that he did not believe all client monies were being held on client account. His oral evidence was that I'm not sure I made any sense of it, and he said that, and this is a quote directly from his evidence, it struck me as nonsensical given the position as I'd understood it to be, and so on. Now, there the judge leaves it. There's no further attempt to analyse what was in Mr. Prentice's mind at that stage, which is a material gap, because clearly that email gave Mr. Prentice actual knowledge about the Reno position. His evidence that it struck me as nonsensical did not let him off the hook, because if it was nonsensical, given what he had previously done in relation to the Reno money, he clearly had to make urgent inquiries to find out what had gone wrong and how matters could be put right and misstatements could be corrected, but he did nothing. All of that was entirely consistent with our cases to knowledge and condonation, but with respect, the learned judge does not do enough. Indeed, he does, with respect, nothing to explore the implications of the February 2018 evidence.
You've got to tie it in to the sending of the false letter in relation to Reno, which was sent on the 22nd of June 2017. So we've got Mr. Prentice saying that the position he understood it was that the money was in the account, and that's why it's nonsensical. Judge saying he was reckless when he sent a letter saying it was in there because he hadn't concerned himself with whether it's true or false. So taking that as the minimum position that he's in, he's already sent out a letter not caring whether it's true or false relating to the position, maintains that's the position here, but he now gets something that's nonsensical and makes no sense, and he does nothing about it.
Yes. And there is no analysis in the judgment of what inferences should be drawn from his inaction in response to his receiving the email in February. That's the position. And then, as the final part of the Reno saga, we get to the important section at paragraphs 95 to 99, which deals with the working out of Mr. Jones's plan to deal with the fact that he is being asked to repay that which the firm should repay, namely the Reno money, but he either can't or won't. And one question, of course, for the judge was whether it was a question of can't or it was a question of won't. The starting point, I think, is at tab 39 in supplemental 1. I could go to that. May 2018, Mr. Jones to copy to Mr. Prentice, to a Ms. War, but copy to Mr. Prentice. And this email is revealing. It starts, we need to formalize our exit from this deal, which is an interesting way of referring to the fact that he is seeking to deal with to manage the fact that the firm should be holding Reno's money, but isn't. Goes on, I have marked up the statements with what we need to adjust for and put these on your desk, and we then need to add back in time we wrote off or did not record in 2015, 2016, 2017. We then need to generate and serve formal invoices, etc. Then reading on, bringing in Mr. Prentice to this operation, V will let us have a form of letter to go with the bills, so on. We will be exercising a formal lien held over the Reno funds in respect of the unpaid fees. V will speak to counsel to ensure that our approach is right. Let's try and get this off by midweek, as our letter went to court on Friday, and we need to ensure that we can defend our position if challenged by lawyers. And then if we see this development of the scheme working itself out, we go on to tab 42.
What does it mean by our letter went to court?
I don't think we discovered what that meant, my lord, I'm afraid. We did not have documents reflecting any court action in relation to Reno at this point. And then completing this part of the story, one goes to tab 42. And one can pick it up at the second page of that tab, page 181. Foot of the page, Mr. Jones to Mr. Prentice and others, asking in particular Ms. War, please may I have so expressed, WIP breakdown against which we have invoiced. We will make reference to the time in our letter, but need to show all the time in a single Excel sheet. Ms. War responds, hi Stephen, as advised before, I do not have all of the time entries for backup. You manually added time, so there is no backup. If you look at the last page of the invoice, you will see the time per fee earner. I have also added this below, and then the hours, the chargeable hours are there set out. The court will see those chargeable hours, which amount in all to 681 chargeable hours, and that is to be compared to the breakdown of chargeable hours that we find in this file at tab 18.
Well, this is the contrast the judge recorded.
Indeed.
In his judgment.
Indeed. And I simply give my lord the reference. The comparison is with the document at tab 18, page 102. And there is a very striking difference between the chargeable hours that were recorded at that point and those subject to Mr. Jones's manual adjustment. And obviously, for present purposes, one striking aspect of this was that Mr. Prentice's chargeable time has moved from 6 hours to 86 hours. It was clear, is clear, and it was clear to the learned judge what was going on there, and he makes very properly some very damaging findings at paragraphs 98 and 99 of the judgment, paragraph 98, he says in effect, again, he expresses himself in a relatively benign form when he says there was neither professionalism nor integrity in what was happening, but in effect, as I think my own friend concedes in his skeleton, that is a finding of a dishonest inflation in purported chargeable hours that is designed to increase the sum allegedly due from the client in order to reduce or extinguish the liability to make a repayment to Reno. No doubt about that. And there's an important final sentence in paragraph 98. Mr. Prentice's evidence under cross-examination at trial that he did not, before March 2019, see any evidence that Mr. Jones was acting in breach of the core conduct principles is contradicted by this episode. That was a big lie, another big lie that Mr. Prentice told at trial. He maintained that until March 2019, he had never seen anything suggesting a want of integrity on the part of Mr. Jones. Well, that for a number of reasons, but in part this episode was clearly false. Then at 99, the learned judge says this: although Mr. Prentice did not accept this, the purpose behind raising the bills was plainly to reduce or extinguish an amount that had to be repaid. But that does not mean it was to reduce an amount of client monies that could not be repaid. That was a possibility, but not one that I am satisfied that Mr. Prentice knew or suspected. I respectfully submit that partial exoneration of Mr. Prentice is wholly unsustainable given the material that has been shown to the court and given the material that was shown to Mr. Prentice and which the judge had seen.
Well, if he knew it was Reno money, he's got to know that it's to fail to pay back Reno what is owed to Reno. And
indeed.
Reno's a client.
Indeed. And when one sets the whole, this unhappy saga firmly in context, and when one has regard to the cash flow crisis in late 17 and early 18, when one considers the grave nature of the fraud that was being carried out on this client by inflating chargeable hours, my respectful submission, it may be my last today, is that it is a finding that Mr. Prentice at some level knew that the Reno money had gone and Mr. Jones was covering his tracks, partly by inflating a lien, was compelled, but it was not made by the learned judge.
Can I just understand
Yes.
What the documents show about we have the letter, let me find it, sorry, the Jirehouse letter which sets out the terms of the money being accepted on the settlement. Can you remind me where that is?
Yes. Tab 8,
Tab 8, thank you.
I believe.
Yes, tab 8. And that shows the monies would go into Jirehouse general client account. 21st of June.
Yes, indeed.
Then we have at tab 11 an account of Jirehouse Trustees Limited, which appears to show 400,000 coming in.
Yes, it does. It does show that, and it shows certain payments out as well. The accounting position is not entirely clear. The document at tab 11 reflects a Jirehouse Trustees Limited account, but one notes at the top right-hand corner,
Client account for JSBF.
Jirehouse Trustees Limited, client account re John Street Bridge Finance, which the court will obviously recall is the Jones entity, which had purportedly taken a loan from Reno.
And this seems to show a nil balance at the end as well.
It
28.
does, yes.
So it looks as though the money So the money looks like it went into, well, it definitely did go into an overdrawn account.
Yes. Indeed.
It doesn't look as though any of those monies went out to the client account.
No.
So it doesn't look as though it ever went into the client account.
No.
Yeah. Okay.
Although I think that concludes Reno, and I want to tie up some loose ends and give the court any further assistance I can properly give tomorrow morning shortly before my learned friend gets his chance to make his submissions. If that's a convenient moment for the court.
Yes. How long will you be tomorrow?
No more, in accordance with the agreement that we have provisionally made, no more than half an hour. My learned friend may even say that's too long, but no more than 30 minutes, and I hope rather short.
I'm very happy with that, Lord. Thank you.
Very well. Well, we'll rise at lunchtime tomorrow. We can review where we are at that point. But obviously, we have quite a clear timetable now, so we do need to stick to that.
Absolutely.
Thank you. So 10:30 tomorrow.